the matter of appeal and non-tennis association services limited?
Yes, Mr. Lyon.
My Lords, I appear for the appellant in this matter, Mr. Achille, together with my learned friend, Mr. Ross. My learned friend, Miss Bell, is the respondent, the Lawn Tennis Association Services.
We've had a message this morning from Mr. Achille that he's not able to attend.
Yes.
Which we've seen, that's quite all right. There's no requirement for him to attend an appeal as he's legally represented at this hearing.
I'm grateful, my Lord. The only thing is there is a point of practicality with his non-attendance, which is he is watching on the live stream.
Yes.
What I would request is possibly a short adjournment between the finishing of my learned friend's submissions and reply, just to take any instructions that he might wish to do.
Yes.
And that's my only request.
I can't see any difficulty about that. Have you had a chance to talk to Miss Bell about how you're going to divide your half-day time?
So we haven't spoken exactly about that. What I do know is that no point is intended to be taken in relation to paragraph 22 of the respondent's skeleton argument.
Right.
Which is the point about whether or not I can raise all the issues within my skeleton argument.
Good.
So that shortens things somewhat.
Thank you.
But otherwise, I don't think we're going to have any trouble.
Well, we have to finish by 1 o'clock.
Of course.
So that includes scope for a reply.
Yes.
All right. Well, thank you very much. We've read the we've all read the key documents and had a look at reminded ourselves of the principal authorities that you refer to.
I'm grateful, my Lord. As you'll know, then the appeal concerns the definition of the word proceedings for the purposes of Rule 4415. Her Honour Judge Kelly below acceded to the respondent's submission to the effect that proceedings should be defined as effectively synonymous with a claim for personal injuries.
Yes.
It's our case that she was wrong to do so, and the appropriate definition would be that proceedings includes all claims brought by a single claimant in one action.
Yep.
In terms of the starting point, my Lord, we say that the starting point is the natural meaning of the word proceedings. That's something indicated by Lord Sumption in the case of Pleven and Paragon Personal Finance. You should find that at the relevant part at page 28 of the authorities book.
Do you want us to have a look at it?
I think it's probably best to just have a look at it because it includes the definition.
28.
Paragraph 20.
Yes.
So you see there, the starting point is that as a matter of ordinary language, one would say that proceedings were brought in support of a claim and were not over until the courts have disposed of that claim one way or another at whatever level of the judicial hierarchy. The word is synonymous with an action. So what we say in terms of the natural meaning is that the word is synonymous with an action. It's not and has never been synonymous with a claim for a single head of loss. That is a novel definition. That much, we say, has been recognised by this court in the case of Brown and the Commissioner of the Police for Metropolis. That case, as you'll be aware, my lords, dealt with the distinction in relation to 4416, and particularly the distinction between the words claim and proceedings used in that rule. I think probably best to take your lordship's attention to just a couple of paragraphs from there.
To Brown?
To Brown, if you would.
Okay.
Page
so that's
13
the first
and 14.
authority. Yeah. Yes.
So
this is paragraph 31.
31. So starting from if the proceedings. So if the proceedings also involve claims made by the claimant which are not claims for damages for personal injury, then the exceptions of 4416(2)(b) will apply. And 33, the exception at rule 4416(2)(b) was designed to deal with a situation where a claim for damages for personal injury was only one of the claims being made in proceedings. So what I say there is that Lord Justice Coulson was taking a distinction between the meaning of those two words, proceedings and claim, with proceedings being the umbrella term. And that is obviously for the purposes of the same part of the CPR. And so what I say is that the two words and concepts are not synonymous.
So proceedings, that's in 4416?
That's in 4416.
Yes.
Except it's not in 4450. But I'll come on, obviously, when I deal with the sort of the construction as a whole of that part as to whether that is relevant. Brown was considered by Her Honour Judge Kelly below,
Yes.
and I accept that. We can see that at page 77 of the core bundle, paragraph 36 of the judgment.
Yes.
And what's being considered there is the background to QOCS,
Yep.
and Brown is quoted in relation to that. And also at page 80 of paragraph 43, which was a response to the submission made by my client below that the personal injury claim should have been allowed to proceed to trial. That is obviously not something that I continue to argue today.
Does she consider paragraph 31?
She does not. And that's what I say is relevant in the context of this, because what she hasn't considered is that there is, within Brown, a clear distinction between those two terms and concepts. Now, it's relevant here to consider the case law in relation to the word proceedings, and I regret that it is somewhat voluminous already. We know that proceedings include appeals in the same matter. So there is not, if you like, a horizontal division for the purposes of QOCS between proceedings. Proceedings apply all the way through. The relevant cases are Howe and the Motor Insurers Bureau. I'm sure you've got the point, but if you want to see it, it's 36 and 37, paragraph 7 and 8.
Thank you.
And Wicks Building Supplies Limited and Blair number 2
Yes.
costs. And again, that's the same point being made. And of course, you'll see referred to in my skeleton, although not in the authorities bundle. My Lord Edis also found this in Parker and Butler. Proceedings also, we know, include claims brought by a single claimant against multiple defendants.
Yeah.
That's the case of Cartwright and Venduct Engineering. I say that case is quite important in relation to this. And I say that because, and here I would turn you to the authorities bundle again, page 46.
To Lord Justice Coulson.
Yes, it's the paragraph 28.
Right.
This is referring to the case of Plevin, which obviously I've already referred you to and which is relied upon by the respondent, where what was being described there is a straightforward division between temporal stages, so a horizontal division across the claim. But what was being rejected explicitly in that is a vertical division, dividing the claim brought in a single claim form into multiple parts to form multiple sets of proceedings. In this case, bringing a single, a claim against multiple defendants. And that was not multiple sets of proceedings, that was one set of proceedings brought against multiple defendants. So those are the cases in which I say this court has effectively broadened, or at least widened in some senses, the definition of proceedings in relation to QOCS. But there are cases, of course, where the court has also narrowed that definition. Those are Wagoner and Weekend Travel. So we know that proceedings do not include claims brought by defendants and third parties, only by the claimant. For the purposes of QOCS, that is, the word of proceedings only applies to those claims brought by the claimant. That is, I say, exactly the same as what was being said in the case of Day and Bryant. I will take you to this one. It's at page 102.
Are you going to take us to Wagoner?
I can.
At some point?
I will at some point, but I can take you to it now. It's page 66, paragraph 39 is the relevant paragraph.
It's also cited in the paragraph from Cartwright.
It is.
Yes, it is. And is that That is the relevant part.
That's the relevant paragraph.
Yes.
So, in relation to the point that I was making, which is that proceedings do not include claims brought by defendants, that's clear in paragraph 40, actually just going slightly beyond the highlighting. Thus, in my judgment, CPR Rule 4413 is applying QOCS to a single claim against a defendant or defendants, which includes a claim for damages, personal injuries, or the other claims specified in CPR 4413 1B and C, but may also have other claims brought by the same claimant within that single claim. But what we know from that case is that it didn't apply as between defendants who had brought claims against each other. And I say that is the same point that is being made in Day and Bryant, which did concern CPR 4415. And here, the relevant page is 102, the relevant paragraph is 19. Judgment of Master Thornett in the High Court. That case involved a personal injury claim brought by claimant and a non-personal injury counterclaim brought by a defendant. And Master Thornett's finding, we say entirely properly, was that on striking out the personal injury claim of the claimant, in fact, the entire claim of the claimant, that still engaged 4415, notwithstanding that the counterclaim had not been struck out. We say that must be right, and that is also consistent with Wagoner, that it applies to claims brought by the claimant. But it's not authority, we say, for this vertical division of a claimant's claim into constituent parts, which is what is contended for effectively. So overall, in relation to that first point, we accept that proceedings can mean slightly different things in different contexts, but it isn't open, we say, on an exercise of statutory interpretation to simply give the word a totally different meaning. And that is what we say the respondent is suggesting here, that proceedings meaning effectively a single head of loss is a totally different meaning of that word. It's not a word that can mean anything, and obviously if it were, then it's a word that doesn't really mean anything at all. And as such, it would have no place within statute. It must have a defined boundary of meaning, and we say we have reached that point. In terms of my next point, that is the consistency across Part 44 in general, we say that the interpretation that is applied by the judge below, by her Honour Judge Kelly, would simply not fit with the remainder of Part 44. And the entirety of this part must be read together. We say that because the rules are contained within the same section of the Civil Procedure Rules. The entire section is governed by a universal definition of the claimant. The rules all contain reference to QOCS in their titles. And finally, of course, 44.14.1 is specifically subject to 44.15 and 44.16. So my submission on that point is the rules have to be read together, they have to be read consistently.
Is this submission that the judge's interpretation doesn't fit with the remainder of the whole of Part 44, or doesn't fit with the remainder of the QOCS provisions?
Just with the QOCS provisions?
QOCS, yeah.
Yes, I'm not arguing for a broader interpretation because we have Wagoner, which clearly says that in certain instances that's not the case. In certain instances, proceedings apply to the whole umbrella of claims brought by claimants and defendants, but we know that's not the case in relation to the QOCS.
No, I may have misheard you, but you've cleared that up for me.
My apologies. So we also say that that interpretation would be consistent with what Lord Sumption says in Plevin. And again, I'll refer you back to the authority, page 28 of the authorities bundle, and paragraph 22. So moving on to 29, start very end of 28, start of 29. In the ordinary course, there is a presumption that the same expression used in different provisions of a statute has the same meaning wherever it appears. There is also a presumption that differences in the language used to describe comparable concepts are intended to reflect differences in meaning, but the latter presumption is generally weaker than the former. We say we are in the former category because we're in a situation where it's got to be applied universally across the QOCS provisions. And there is also a submission in relation to the latter category as well, because we say that there will be, and we'll come on to this in the defined term point, there is a defined term that's being imported by the judge below. So if proceedings and claim for personal injuries mean the same thing, and here I think it's probably best to refer you to the relevant rules. They're set out in full within my skeleton argument.
Yes.
Paragraph 27, page 27 onwards of the core bundle, paragraph 15. So firstly, 44.13.1, this section applies to proceedings which include a claim for damages for personal injuries, etc. So again, distinction being drawn between claim and proceedings there. If claim and proceedings being the same thing, there's no need for that distinction. Then we have 44.16.2a. Orders for costs made against the claimant may be enforced up to the full extent of such orders with the permission of the court and to the extent that it considers just where a. The proceedings include a claim which is made for the financial benefit of a person other than the claimant or a defendant within the meaning of Fatal Accidents Act 1976. So again, we're looking at if proceedings and a claim for personal injuries are synonymous, that would be a very unusual provision, it just wouldn't read correctly.
And 44.2b.
Yes, so I'm going to come on to that.
Okay, sorry.
No, it's quite all right, my lord. 44.2b as well, we have the same problem because of the interpretation of that in Brown, which is that this section applies to claims to which this section applies means personal injury claim, one personal injury claim, but it doesn't mean proceedings, and proceedings hasn't been included within 44.16.2b. So again, it would be an unusual reading to find that claim for personal injuries and proceedings are the same word, because otherwise proceedings would be used there. We also say that there is an issue that arises with 44.14.2. This is the section which reads, orders for costs made against the claimant may only be enforced after the proceedings have been concluded and the costs have been assessed or agreed. And the issue we have here is there is a dispute between the parties on this point. 44.14.1 sets out the general rule and is subject to exceptions in 44.15 and 44.16. 44.14.2 does not appear to have that qualification, but it is subject to rules 44.15 and 44.16. But what has been argued below is that actually the whole of 44.14 must be read as being subject to 44.15 and 44.16. Now certainly that's not my reading of it, or a natural reading of it, but in any event that would have, I say, quite a chilling effect on the QOCS regime as a whole, and that particular construction cannot be preferred. And the reason I say that is because essentially you could end up in a situation where you have a standard mixed claim. So by example, let's say a claim for data protection breach together with a claim for personal injury, as was the case in Brown. You have an application that deals solely with the data protection breach aspect, for example, an interim application. The judge makes a costs order against the claimant in that application. there would be nothing if 44.14.2 was subject to 44.16 in preventing a defendant from enforcing or seeking to enforce that interim costs order. Now that may cause access to justice issues with the claimant's remaining personal injury claim in the difficulty of funding that to trial. So I say that it cannot be right that can, and 44.16 I don't believe has ever been applied in an interim context, not to my knowledge, and certainly having looked at it, I haven't found any examples.
So your submission is that we should read subject to rules 44.15 and 16?
Only in relation to 44.14.1, but not in relation to 44.14.2. 44.14.2 isn't written as being subject to them, but that is the point that has been made and acceded to below. It's also suggested, and this secondary interpretation perhaps has more merit, but is still flawed in my submission, that if you interpret proceedings across the QOCS regime rather than just in 44.15 as meaning a claim for personal injuries, then of course 44.14.2 would still fit with what the respondent intends to do, because you would have a situation where the personal injuries claim would be at an end, and accordingly there would be no bar to enforcement by 44.14.2. The problem with that interpretation is, for the reasons I've already specified, the difficulty of the inconsistency between 44.13 and 44.16, and it must be an unusual statutory construction to have inconsistent meanings of that word proceedings across those provisions, particularly in this case because 44.14.1 makes specific reference to 44.16. So having two different meanings of the word proceedings as between those two would be a very unusual statutory construction, I say not to be preferred. So that's the second point in relation to the inconsistency. My third point deals with the consistency with CPR 3.4, the strikeout provision. This is described within my learned friend's skeleton argument as the source of the strikeout power. It was a point to which Her Honour Judge Kelly acceded below. It's correct that CPR 3.4 and CPR 44.15 are read quite differently from one another. And that is because we have CPR 3.4 applying to the striking out of all or part of a statement of the case, so no mention of proceedings. And further, the first section 3.4, that it's the court may strike out the statement of case if it discloses no reasonable grounds to bring the claim. Again, no mention of proceedings. However, what we say is that doesn't take the exercise of statutory interpretation any further in relation to 44.15, because 44.15 is written in a way that is totally different. It is not meant to be read together in that sense, because we know that 3.4 applies in instances where 44.15 does not. 44.15 does not bite, for example, in what I would describe as a procedural strikeout. So if there's a strikeout for failure to comply with rules, practice, directions or orders, then 44.15 has no application.
Now the judge deals with this towards the end of the judgment, doesn't she?
Yes, she does. I believe...
Page 82, 48?
That's the one, yes.
Okay. That's where she summarises the respondent's position.
Yes. Now I say that there is no support for the respondent's position in that because of the difference between them, and because of the situation where you can have effectively a claim that is struck out validly under 3.4, which doesn't engage 44.15.
Does the judge accept this submission?
I don't believe that submission was made.
I mean, that is just 45 and 49 are just a recital of the submissions, as I read them. And,
Yes.
and I can't. It's not. This point isn't referred to in the conclusion section of the judgment, is it? Or am I missing something?
I don't believe that it's referred to within the conclusions. My reading of my reading of 48 and 49 was that the judge was accepting those submissions, and certainly their submissions made again today, which is why I've dealt with them. But there is a further reason why I've dealt with it as well, which is there may be a temptation to think, okay, so the personal injury claim has been removed from this claim, and therefore QOCS provisions can no longer apply. Well, obviously that isn't the case, because there are situations, we all accept that when a claim is struck out, it ceases to exist. And there are positions within the rules where a personal injury claim has been struck out for a procedural sanction, ceases to exist, but QOCS protection continues to apply. And I say it's not a big reach to see another restriction on that, which is that the entirety of the proceedings must be struck out, which is, as I say, how the rule is written before 4415 begins to bite.
So it didn't feature in the judge's reasoning, but you're responding to.
I think I'm heading it
you're
off.
heading it off the pass. Good, well put, Mr. Lyon.
And I say that the reason that it's unsurprising in context, and again, this is part of the more positive submissions to the appellant's case, is because there are alternative routes to enforcement that remain open to a defendant. In this case, they can, obviously, if the remaining case proceeds to trial, and Mr. Achille is successful, there is a provision under 4414(1) for enforcement up to the value of his damages automatically. Secondly, I say it's also possible for a defendant to return to the court at the conclusion of proceedings to seek an order under 4416(2)(b) for any amount of the proceedings, including potentially this strikeout application. There is all it is a bar to is essentially a temporary bar on enforcement until the conclusion of proceedings, and that, in my submission, is not inconsistent with the QOCS regime. It's not that it furthers it, but it doesn't have to further it. It just has to not be inconsistent with it if it's to be given its natural statutory meaning. And so for those reasons, I say that there is no inconsistency there between 3.4, and in fact, there's no inconsistency with the QOCS regime as a whole. The final point, we're pleased to hear I'm already getting there, is the defined term point.
Well, are you going to tackle the judge's reasons, which are firmly based on purpose? Yes,
what I say in relation to that, in terms of purpose, is we don't actually get that far. The issue with purpose only arises if there is a serious statutory ambiguity, or in relation to this defined
serious statutory ambiguity.
So such that you read it and you had no idea what it meant. I would say that it's pretty clear what it means, and proceedings has never been defined in the way that the respondent contends as just part of a claimant's claim. It would mean that this claimant had brought more than one set of proceedings on a single claim form, if that approach is to be preferred. And again, that's never been the definition that's been used. But the important thing is, because the reason you don't get that far, I say, is because what has to be imported is a defined term. So the defined term is a claim for personal injuries, and that's defined in Rule 2.31. And it's quite important what that definition is, because the definition in 2.31 is proceedings which include a claim for damages for personal injuries. In which there is a
Which
claim.
one are we looking at? 44?
So this is 2.31. It's set out at page 29, paragraph 16 of the skeleton argument.
So you're going right back to rule 2.31.
Yes, interpretation.
This is paragraph 16 of your skeleton.
Yes, it's set out in full there. So the term claim for personal injuries, which is what the reasoning that the judge uses as saying this is the appropriate term to define the proceedings means, and even proceedings in which there is a claim for damages in respect to personal injuries, is defined within the rules already. And that creates, I say, quite a big problem for the respondent in importing that definition into the word proceedings. And that's why you don't engage the purpose point at that stage, because you're already having to deal with importing a term that I say could only have come about in a drafting mistake, essentially.
Right, so we're here seeking to reconcile 2.31, or the phrase claim for personal injuries there, with 44.
Precisely.
The QOCS provisions.
And the QOCS provisions as a whole.
And you say that it's not possible, is this your submission, it's not possible to reconcile what's said in 2.31 with 44.13.1.
That is my submission, that you, without reading the term in, claim for personal injuries, and it is not possible to reconcile those two parts. So the word proceedings can't mean exactly the same as a term that's already defined within the CPR.
Well, 2.31, the term is claim for personal injuries.
Yes. And I think what Her Honour Judge Kelly defines it as is the personal injury claim alone.
Can we just look at how the judge dealt with this?
Yes, of course. So it's, I think, paragraph 51. No, sorry, paragraph 50. In my judgment, the construction of the word proceedings in CPR 4415, it's page 83, my apologies.
Yeah.
4415.1 as meaning the personal injury claim alone, rather than requiring the strikeout of all claims, both personal injury and non-personal injury, is consistent.
Well, she doesn't really address there whether what she says is consistent with the definition in 2.3, does she?
No, which is particularly strange in my submission because she does refer to the definition. So she does consider the definition in her judgment, but it isn't referred to in any way in the reasoning. And I accept that this wasn't a point it precisely made by Mr. Achille as a litigant in person below. So that may be part of the reason why she hasn't dealt with it.
I wonder whether 4413 is not a freestanding definition, because if it's simply adopted 2.3.1, it wouldn't need to say proceedings which include a claim for damages, because claim for personal injuries is already defined as a claim which includes claim for damages.
Yes, and I think that's partly one of the issues, is that if that's what was meant, then no doubt they would have used those words. It can't be separate from the interpretation of the CPR as a whole and from the interpretation of the provisions as a whole. And I think that part of the problem is that the exact wording of 2.3, if it was merely a claim for personal injuries, means a claim for personal injuries on its own, then that might be less of a problem. But because it's actually proceedings in which there is a claim for personal injuries, it's broader.
So it includes a mixed claim.
Yes. Which does, I say, cause a problem with suggesting that proceedings must mean the same thing.
Do you want to say anything about what the judge's reasons for her purposive construction?
Yes, I think that what I'm going to suggest in relation to the purposive construction.
I mean, your main point is we don't get that far.
We don't get that far.
But if we do get that far, do you have any comments or submissions about it?
So what I say is that the suggestion by the appellant as the appropriate definition as applying to all of it is not inconsistent with that purpose. And the reason I say that is because there is still a significant disincentive on claimants to bring either spurious or fraudulent personal injury claims tacked on to a regular
Unmeritorious is the judge's words.
I believe it is, yes.
Disincentive, and how would you define that?
So that's actually several-fold, I suppose. The first is that you have any claim that is tacked on in any way deliberately. I think that's certainly what's implied in Siddiqui as something that the rules are seeking to prevent.
Yeah.
The deliberate adding on of claims. That claim is liable to be fraudulent, which can, of course, lead to the entire claim being dismissed, not merely the personal injury element under Section 57 of the Criminal Justice and Courts Act.
So a fraudulent claim tacked on to a non-fraudulent claim.
Yes, can lose the whole thing.
Under
Section 57 of the Criminal Justice and Courts Act. And then,
or indeed 4416.
or indeed 4416.
Yeah.
And then further to that, you've also got the risk that if you've tacked on a spurious claim, let's say not a dishonest claim in some way, but you've done it deliberately to gain the QOCS protection, I think that seems like a pretty obvious example of an abusive process. And there are provisions allowing for the abusive process which would strike out the whole claim.
same point, really.
And exactly the same point would apply. And of course, in that instance, 4415 would apply because you would have struck out the entire
Yes.
claim for the abusive
Either way,
process. So there are provisions to prevent claimants bringing these more spurious or less unmeritorious claims.
So if we look at the judge's reasoning in paragraph 50,
Yes.
third sentence, there are no sound policy reasons why a claimant pursuing an unmeritorious PI claim tacked onto a non-PI claim should be in a better position than a litigant pursuing an unmeritorious PI claim alone.
So my submission is they're not, because they're at risk from these other provisions that would render not just the PI claim being struck out, but the entirety of their claim.
So the premise for the third sentence is wrong, you say.
Yes.
And then the fourth sentence, the premise for the fourth sentence is wrong as well.
Yes, and I think there's also the point as well which I've made, which is the point in relation to there being other options for enforcement for a defendant. So it is only actually a very, very small restriction in what the defendant can do. It's not.
It's only one option that's
Yes,
barred,
and it's not
one
allowed.
door that's closed.
Yes, and it's not allowing litigation without restraint on behalf of the claimant. It's simply, what I say is that the reason you don't get so far as having to read into anything to it is because it's not necessary to do so to make the provisions all work. And so that brings me back to this defined term point, which is that it's very unlikely, I say, that the term was used inadvertently in 4415, the proceedings, instead of a claim for personal injuries, which is already the defined term, was used, because it's a term already defined. It's used fairly extensively within the civil procedure rules in general. Just for your note, a brief search shows it turns up in 16.3 in relation to statements of case, 26.6 in relation to allocation, practice direction 25B in relation to interim payment.
Is this Control F that's found?
Pretty much. My lord. 27.1 in the scope of the small claims track, 31.5 in disclosure, and 45.29G in relation to fixed costs. I think there probably are other provisions where it is mentioned, but those were just a very brief search. So it's used extensively across the CPR already. It would be extraordinary, I say, for it to have just been missed here. It's much more likely that proceedings is intended to mean something different. And that's partly because the reading that is proposed, the reading that allows it to be a single head of loss and to vertically divide the claimant's claim into multiple sets of proceedings, is an idiosyncratic reading of the word proceedings. It is much more likely that the natural meaning was meant. So this brings me on to the Inco Europe limited and first choice distribution point. And my lords, you'll no doubt be aware of the principle. I've put it anyway in 87 of the authorities bundle.
Yep.
And these were the principles, I say, which the learned judge had to apply her mind to if she was to read in words. I say that is exactly what she's done. And the
Yes.
three-part test is between F and G. So the court must be abundantly sure of three matters. One, the intended purpose of the statutory provision in question. Obviously, that is where the purpose is relevant. But two, that by inadvertence, the draftsman has failed to give effect to the purpose of the provision. And three, the substance of the provision that Parliament would have made, although obviously not necessarily the precise words. Now, I think the difficulty there is the lack of evidence of inadvertence because of the fact that there is this defined term.
So it's two.
Two is
The second principle that you say is the problem.
is the real sticking point.
Yeah.
Obviously, if what I was suggesting was totally inconsistent with the purpose of QOCS, and that it didn't just further it, but actually cause a huge problem with it, then it might be a different matter. Although you would still run into the inadvertence problem, but you might be able to give different weight to it. What I'm saying is that in relation to question 1, it's at best it's consistent with it. It may not further that purpose, but it is not inconsistent with the rest of the rules and certain limitations, and of course the fact that the claimant is already somewhat limited in what litigation he can conduct without consequence.
Well,
And
what
so-
your point is you accept the purpose of the provision
Yes.
as identified by the judge, but or the provisions as a whole. But you don't accept that it was necessary for the purpose to be achieved for this particular provision to be couched and to be interpreted in the way that was proposed.
Precisely.
Because that didn't undermine the overall purpose.
Yes.
Because the purpose was achieved, as you've attempted to illustrate, by other provisions.
Precisely. And further to that, of course,
And there's no clarity about there being any inadvertence. That's your point.
yes.
Yes.
And I think that in relation to that inadvertence, obviously, the fact that the terms proceedings and claim are used distinct from each other within those QOCS provisions adds support to that. Again, it would have been perfectly possible to make it essentially all make sense with claim for personal injuries, although it would have need quite a rewrite, but it would have been possible, and it wasn't done. So I think it's important here to say I'm no longer arguing that it was necessary for the claim to proceed to trial on the personal injury claim, which is what my client had argued below. And I totally agree with what the learned judge said in the first instance on that point, and I think she may have been drawn in to that point in addressing certain issues, which is that would not be consistent with the overriding objective. It would provide a huge disincentive for strikeout and for claims to be dealt with in a more summary manner where they were very weak. But in my submission, that's not the case if personal injury claim isn't proceeding to trial, because the defendant does receive a significant benefit through the striking out, both in terms of the cost of fighting the personal injury claim to trial being no longer incurred, and the potential risk in litigation being significantly reduced. But also, it is an exercise that could well lead to a benefit in costs, just not an immediate benefit in costs, for the reasons that I've given. And therefore, there's also no waste of court time in having a strikeout claim and then a separate claim for non-personal injury damages, but still within the same proceedings.
Is your argument about Inco Europe meeting an argument made against you, or is it another heading off at the pass point?
So this is a point that I put directly in my positive case, as it were. The judge didn't address the case or the test within it. I accept that it wasn't raised, so that may explain that. But it is also a point which has to say that it makes it more likely that the natural meaning, which is what I propose is the correct meaning for word proceedings to apply to all claims, is more likely to be correct, because you'd have to apply your mind to that test, and if you did, you would still find that it would be very difficult to import the defined term that respondent seeks. And I say, in fact, impossible.
Yes. All right, but I don't think, I might be wrong, but I don't think there is an argument against you that there is a drafting mistake which we can correct.
I think
the argument against you is simply that proceedings means what the judge said it meant.
Yes, it's argued in the alternative in a single paragraph within my respondent's, within my learned friend's skeleton, where essentially she says it's not a mistake because it was correcting a semantic ambiguity. But if it was a mistake, the judge did apply her mind sufficiently to the INCO test, and it would have been met in any event. I think that the final sort of to bring it all round, the reasoning I say behind 4415 is to prevent a defendant being left in a position where the entire proceedings have been dismissed at an early stage. They're prevented from enforcement otherwise, without presence of 4415, by 4414(1), or they're alternatively left pursuing a freestanding application after the dismissal of proceedings for a finding of fundamental dishonesty. It's why I say that there's an automatic entitlement for where there's an entire proceedings dismissed, because that kind of summary dealing with costs is much more suited to those summary hearings. Whereas dealing with costs in a more detailed sense at the conclusion of the proceedings following a trial, again, is more suited to the 4416 arguments. My lords, those are my submissions, unless I can assist you any further at this stage.
Just to be clear as to what you're saying, you say that 4416 2b would be available in this case to enable the costs of the personal injury claim to be enforced against the claimant by virtue of the fact that it is a mixed claim. So that paragraph B is not limited to the costs of the claim which is not for personal injuries.
Yes, because the court could conclude it's to do with the extent that it considers just in the case of a mixed claim. And if the personal injury claim has been struck out for reasons that it didn't disclose a cause of action, the court might well think that it was just at the conclusion of proceedings to allow that cost order to be enforced.
So 4415 is simply a temporal limitation. Say that under 4416 you've got to go through a broad discretion in the court.
Precise.
Yes, I see. Okay, thank you very much.
Thank you very much, Mr. Lyon. Yes, Ms. Bell.
My Lords, clearly this appeal concerns the meaning of the term proceedings in CPR 4415(1), specifically whether it means, as the appellant alleges, all the claims, so both the personal injury and non-personal injury claims brought by the appellant against the respondent, or only the personal injury claim as was found by Her Honour Judge Kelly. The respondent opposes the appeal and seeks to uphold the order of Judge Kelly for the reasons she gave. The court's no doubt familiar with the factual background to the appeal, having had the benefit of the skeleton arguments, but there was one particular point that I needed to flag up, which deals with something I picked up on in Mr. Lyon's skeleton argument. In his claim against the respondent, the appellant sought damages for personal injury in negligence and also damages for personal injury pursuant to Protection from Harassment Act 1997 and the Equality Act 2010. So it's not simply the case that the personal injury claim was attached to the claim in negligence, and so only to one of the three causes of action which the appellant relied on. In addition, of course, the claimant sought damages for injury to feelings for the alleged harassment under the 97 Act and also under the Equality Act by way of compensation.
And those were not struck out.
That's right, Your Lordship. So those claims for injury to feelings based on the causes of action of harassment and racial victimisation survive and remain to be determined by the courts. What I should also point out is that at the hearing before District Judge Dickinson, she struck out not only the claim for damages for personal injury insofar as it was brought based on the cause of action in negligence, but also those claims for damages for personal injury brought under the 1997 Act and the Equality Act. She struck out all the claims for damages for personal injury. And that's obviously clear from the wording in the order itself. And I only highlight it because there was some suggestion in Mr. Lyon's skeleton argument that it was only a claim for damages for personal injury attaching to the negligence cause of action that was struck out.
You say the injury to feelings survives and remains to be determined. Has anything happened since the judge's judgment?
We're at the stage, Your Lordship, where there was a case management hearing was due to take place in September 2019. That was initially adjourned pending the appellant's application for permission to appeal. I understand it's recently been relisted and is due on for hearing in November, at which point it's anticipated that the claimant's outstanding application for permission to amend, which you'll have seen referenced in the transcript, would be dealt with alongside other case management matters. So it hasn't.
So the whole thing's been frozen, really, more or less, by this appeal process. The first appeals. Okay. Right.
The respondent's position is that the judge's reasonings for the judge's reasons for finding as she did can be summarised as set out in paragraph 29 of my skeleton.
Right.
What I say there is that the judge concluded that proceedings in Rule 44.15.1 should be interpreted as meaning only the personal injury claim, because such a construction was, first of all, consistent with the overall context and purpose of the POCS regime. It was, secondly, consistent with the court's and the parties' obligations under the CPR to further the overriding objective. Thirdly, it was consistent with case law insofar as there are reported decisions on the meaning of the word proceedings in Section 2 of Part 44. And finally, that it was consistent with the source of the strikeout power in Rule 3.4.
Well, now, can we just look at exactly what her decision, the reasons were? She recites a lot of argument, but her conclusion sets out her reasons, doesn't it?
It does.
In 50, 51, 52. And as I read 50, 51, 52, she doesn't expressly endorse what you said in 49. Is that right?
Your Lordship, I certainly, my ears pricked up when you asked Mr. Lyon about this very issue. I have to confess I had read 48 and 49 as Mr. Lyon had done, albeit I accept.
Meaning that it's just you're deciding what you said?
No, actually I'd read it the other way. Okay. I'd read that as her accepting, in fact, that her interpretation of the word proceedings was in fact consistent with...
Well, you may be right. Let's look, shall we? As it's your submission, and let's see if she accepts it. Might have been
my innate optimism, I think, Your Lordship, but certainly I accept that passage of the judgment appears before the conclusion section.
Shall we just have a look?
Before we do, can I just point out that One thing you don't seem to say in paragraph 29 of your skeleton is that the judge's conclusion is consistent with the actual wording of the other QOCS rules, which is a big part of the argument against you.
Yes, that's right, Your Lordship, because I don't, certainly from my recollection, there was no argument at first instance before the judge that any such interpretation was inconsistent with the remaining provisions of QOCS. Certainly not put forward on Mr. Achille's behalf, and therefore I don't think that was a matter which therefore featured in her judgment in terms of her reasons for reaching the conclusion that she did.
Well, it's still a point you'll need to deal with.
Yes, absolutely, and I was certainly anticipating that I would have to deal with that.
All right, thank you.
I am conscious that Your Lordships have read my skeleton argument, so be familiar with why the respondent is saying that the judge was right to dismiss the appeal, and of course with the terms of the judgment itself. So unless Your Lordships want...
Can we just look at this point I was asking you about
Oh,
whether 48 and 49 is part of the ratio? Can we just have a look at it?
Yes.
It would be helpful if she'd said Miss Bell added, Miss Bell submitted, Miss Bell further contended, but she doesn't.
Yes.
So you say that she accepted it, do you?
I had read it in that way, although I appreciate, given the way in which paragraph 48 begins with the respondent submits, that one could potentially read all of that in that context.
All right. Okay. Well, thank you. You proceed as you wish, Miss Bell.
Your Lordship, I was just about to say that I was proposing to focus on the additional points the appellant had raised, rather than necessarily developing the points that I had put in my skeleton argument. Although if you do wish to hear from me in relation to any particular points, I seek to focus on point 1, the overall context and purpose of the QOCS regime, and the consistency with the case law.
I think you need to focus on the point my Lord raised as well, as part of that. Yes?
Yes, absolutely. The first and most important reason the respondent says that the judge's interpretation of the word proceedings was correct was because such a construction was consistent with the overall context and purpose of the QOCS regime. It's common ground between the parties that the Supreme Court decision in Plevin, which you've already obviously been taken to, confirmed that the meaning of the word proceedings must depend on its statutory context and on the underlying purpose of the provision in which it appears. And that's paragraph 19 of the Judgment of Law Assumption. And if further confirmation is needed that the meaning of proceedings in CPR 4415 ought, as a starting point, to be ascertained from the QOCS rules themselves, the respondent would further refer to the judgment of Justice Voss in the Wagner case. As a result of that, the respondent submits that it cannot really be doubted that the judge was right to adopt a purposive construction which took account of the overall purpose and objective of the QOCS regime in general.
Is Wagner the main plank on which you base your case?
Certainly in relation to the purpose issue, but insofar as your Lordships will have had the opportunity to consider all the authorities, wherever there is a question mark over the meaning of particular QOCS provisions, the court has frequently fallen back on, I think almost exclusively fallen back on, when interpreting them, the purpose of the QOCS regime in which those provisions appear. Wagner is just simply one example of where it was specifically spelled out by Lord Justice Voss that insofar as there is a question mark over the meaning of a particular provision in the QOCS regime, that it's appropriate to look at the purpose of QOCS. In terms of the decision, Wagner I rely on as an example of a narrow interpretation being taken to a particular rule, in that case, obviously CPR Rule 4413.
I understand why you submit that the judge's interpretation is consistent with the overall context and purpose of the regime. Actually, Mr. Lyon makes the same submission, and it's possible that both interpretations are consistent. Do you go further and say that the appellant's construction is inconsistent, and if so, why?
I do. I was going to highlight, Your Lordship, that the key difference between us relates to the effect in the event that 4415 isn't to be interpreted in the way that I'm seeking to contend. Mr. Lyon has placed much store on the fact that essentially it doesn't pose any real problem for a defendant, and therefore doesn't undermine one of the fundamental purposes of the QOCS regime to deter frivolous personal injury claims, because he says even in circumstances where 4415 is interpreted differently, as the appellant contends, the respondent essentially has as good an outcome from a cost perspective. The only difference, he will say, is that there'll be a slight delay in the question of costs being determined. I say that's not quite right. An automatic right to enforcement of costs, which would follow in the event that the respondent's interpretation is preferred, is very different to the requirement to fall back on essentially the provisions of CPR 4416(2)(b), which is obviously the provision that was at issue in Brown. In those circumstances, the wording of the provision itself which makes clear in such circumstances orders for costs may be made against the claimant, may be enforced up to the full extent of such orders with the permission of the court and to the extent that it considers just, that there would be a twofold discretion to be exercised by the court. That, of course, would leave significant uncertainty for a defendant who has obtained the successful strikeout of an unmeritorious personal injury claim, in addition to any delay pending enforcement. I'd also draw your Lordship's attention to the way in which that discretion has been interpreted and was interpreted by Lord Justice Coulson in Brown. Some guidance is...
You said a twofold discretion. What are the two?
Well, it requires the court to consider whether permission should be granted, and in terms of deciding the extent of the court order that's made, the court has to make the order to the extent that it considers just.
Isn't that the same question?
Well,
you do it if you consider it just, and you don't if you don't.
Well, it's do it and also to what extent, I think, Your Lordship. So it may well be that, for example, if the claim was struck out under 4415 and 4415 is to be interpreted in the way that I sought to interpret it, there was no question at all that the respondent was entitled to its costs in full as summarily assessed. That position might be different. It may well be that, yes, the court takes the view that the defendant is entitled to its costs, but limits it in terms of a percentage. And that's exactly what I think happened in Siddiqui, where 25% of the costs were awarded. But the point that I'm seeking to make is that there's extensive court discretion involved in the making of an order that leads potentially to uncertainty, which in and of itself could potentially act as a incentive for bringing frivolous claims. I don't accept, as Mr. Lyon has said, that his position is essentially neutral insofar as the purpose of QOCS is concerned. He says it might not further the purpose, but essentially isn't inconsistent with it. I submit that it is inconsistent, and there is a significant difference between the outcome for a respondent in the event that 4415 is interpreted in the way I seek to uphold, or indeed if as compared to the interpretation put on it by the appellant.
Yes, if this appeal is, if Mr. Lyon is right, I suppose this appeal has really been pretty much a waste of time. It would have been better to get on with the remaining bits of claim and then make the application under 4416.
I think the difficulty in that respect, Your Lordship, arose because the position adopted by the appellant up until the second appeal was very, very different. Mr. Achille himself took the view that the respondent, having chosen to apply the strikeout or chosen to apply for the strikeout of the personal injury claim, it wasn't indeed open for the respondent at the end of the case to pursue a claim for costs on a mixed claim basis under 4416.
Yes, I see. Right.
But
Right,
just,
sorry, I interrupted you. I think you were going to Brown.
yes, I was just about to refer to Brown, Your Lordship, just to illustrate the way in which to date the Court of Appeal has interpreted the correct approach to the exercise of discretion under 4416(2). It's paragraph 57 of the judgment of Lord Justice Coulson, which starts on page 17 of the authorities bundle. You'll see there that what is said is that the fact there is a claim for damages in respect of personal injury and a claim for damage to property does not mean that the QOCS regime suddenly becomes irrelevant. On the contrary, I consider that when dealing with costs at the conclusion of such a case, the fact that the QOCS protection would have been available for the personal injury claim will be the starting point and possibly the finishing point of any exercise of the judge's discretion on costs. If, unlike the present case, the proceedings can fairly be described in the round as a personal injury case, then unless there are exceptional features of the non-personal injury claims, such as gross exaggeration of the alternative car hire claim or something similar, I would expect the judge deciding costs to endeavour to achieve a cost-neutral result through the exercise of the discretion. In this way, whilst it will obviously be a matter for the judge on the facts of the individual case, I consider it likely that, in most mixed claims of the type that I've described, QOCS protection will, in one way or another, continue to apply. So there seems to be a presumption, in circumstances where there is a genuine, or at the start there was at least a genuine personal injury claim, there seems to be a presumption that if considering the question of costs under CPR 4416, absent exceptional circumstances, that QOCS will continue to apply. Going back to my argument in relation to purpose, I've sought to suggest that it was correct for the judge to take into account the purpose of the QOCS regime in general, but that begs the question of what in fact is that purpose. It's the respondent's position that the purpose of the QOCS regime is twofold. Firstly, it seeks to protect claimants claiming damages for personal injury, and I'd emphasise that, from adverse cost orders, thereby maintaining access to justice. One has that purpose on one hand, and then on the other hand, at the same time, I'd say the other purpose of the QOCS regime is to seek to deter personal injury claims which are unmeritorious. And I think perhaps the most succinct summary of the purpose of the QOCS regime was given by your Lordship in the case of Blair, where in paragraph 29, your Lordship stated that the purpose of the QOCS regime is to facilitate access to justice for those of limited means.
Yep. What paragraph is
That's
this?
paragraph 29, page 80 of the authorities bundle.
I have a recollection I was drawing on what my Lord had said, and Lord Justice had said, or Mr. Justice, as he then was in an earlier case. Yes, Parker and Butler.
Yes, I think your Lordship goes on immediately afterwards to reference that case.
So which bit of Blair are you talking about? Were you saying?
Paragraph 29, page 80.
Yes.
It says in each case, the court held that the word proceedings had to be interpreted to reflect the legislative purpose. The purpose of the QOCS regime is to facilitate access to justice for those of limited means. It's a point that is echoed in the other cases in the authorities bundle, unsurprisingly, in the light of what's stated, or what was stated in the Jackson report. So, for example, Lord Justice Voss made a similar point in the Wagoner case. It's paragraph 36 on page 65. He says there, suffice it to say that the rationale for QOCS that Lord Justice Jackson expressed in those sections came through loud and clear. It was that QOCS as a way of protecting those who suffered injuries from the risk of facing adverse cost orders obtained by insured or self-insured parties or well-funded defendants. And I would emphasise that it's important to note that the objective of QOCS, that of ensuring access to justice, is focused specifically on ensuring access for justice for claimants in personal injury claims. And it's for that reason that it's well settled now in the light of Brown that QOCS protection applies only to personal injury claims and not to other types of claim. And it was a point that was put beyond doubt by Lord Justice Coulson in that case. In particular, in paragraphs 32 and 54. So paragraph 32 appears on page 13 of the authorities bundle. I think you were taken to the similar passage, although in a slightly different context, by Mr. Lyon. So it's the second sentence. The QOCS regime only applies to claims for damages for personal injury. It does not apply to other types of claim.
So where are you reading from now?
It's paragraph 32
Yes.
on page 13.
Sorry.
And a similar point was made at paragraph 54 on page 17. The judge.
Are you going to take us to what Lord Justice Voss said in any detail
Specifically in what context?
on this context?
I hadn't proposed to, but as I mentioned at the outset, there are a number of. It's a point that he's echoed throughout all of these cases. I don't think, and I don't read what the appellant says to challenge in terms of the.
Well, for my part, I think it would be helpful if we looked at some point what he says, particularly perhaps at 38 to 40.
Yes, certainly, for example, paragraph 38 reiterates the point that I was making a moment ago. It is insofar as, well, in fact, it reiterates 2 points, that the proper meaning of the word proceedings, at least in the provision that was an issue in that case, CPR 4413 has to be defined primarily for the rules of QOCS themselves. But the second sentence, the whole thrust of CPR Rule 4413 to 1416 is that they concern claimants who are themselves making a claim for damages for personal injuries, whether in the claim itself or in a counterclaim or in an additional claim. And obviously that explained why the court in that case went on to conclude that it wasn't appropriate that QOCS covered a claim by a third party and thereby essentially adopted a narrow interpretation of the word proceedings in that context.
What about the sentence in paragraph 39? I think the word, the third sentence, I think the word proceedings in 4413 was used because the QOCS regime is intended to catch claims for damages for PI where other claims are made in addition by the same claimant. What does that tell us about the use of the word proceedings in these rules?
Well, certainly Mr. Lyon would emphasise this paragraph to indicate that there's a clear distinction between proceedings and claim in CPR 4413. It therefore cannot be right that the same term proceedings in Rule 4415 can bear a different construction. I would take issue with that.
With which part of it?
in relation to the idea that simply because, well, I'd accept that in 4413 there has to be this, there is a distinction made by dint of the fact that both terms are referred to within the same paragraph, proceedings and claim. Clearly in that section it's envisaged that they mean different things. However, I don't accept that the mere fact that that is the case in CPR 4413 necessarily precludes the court from interpreting the word proceedings in 4415 somewhat differently. I would fall back on the point that in Plevin it was made clear that the meaning of the term depends on the specific statutory context. I would submit that the mere fact that both provisions appear within the QOCS section does not mean that they therefore have the same statutory context warranting a similar interpretation. 4413 is essentially the gateway provision to QOCS. It's designed to further the first purpose of QOCS that I mentioned, of ensuring access to justice. It therefore makes sense for 4413 to be drafted in such a way so as to broaden the scope of the QOCS provisions. The reason why proceedings ought to be interpreted differently in 4415 is because that provision is in effect the provision that furthers the second purpose of the QOCS regime, that is of deterring frivolous personal injury claims. So I would fall back on the difference in purpose of the two provisions to explain why it may be that the term proceedings ought not to mean the same thing in 4413 and 4415. The judge in my submission did acknowledge in her judgment the important role that the QOCS regime played in facilitating access to justice, and specifically it was in that context that she cited the cases of Howe and Brown, so it's paragraphs 35 and 36 of her judgment at 77. But what she went on to note in the subsequent paragraphs, and this is 37 and 38, is that via the mechanism of the exceptions to QOCS in 4415 and 16, access to the court was not promoted without restraint. I say she was clearly right to do so because this follows from the fact that one of the necessary elements of the QOCS regime is to deter frivolous personal injury claims. That was a point that was made in the Jackson report itself, paragraph 4.5 in chapter 19, but it was the point picked up on by Lord Justice Coulson in Cartwright in paragraphs 31 and 32. And that's at page 48 of the authorities bundle. If I may in particular refer your lordships to paragraph 31 first of all, which is on page 48, which states the proposed deterrence against frivolous claims or applications was identified as the need to put the claimant at risk of adverse costs orders. Sorry, my apologies, it's earlier on in the paragraph. It says, it's instructive to note that in paragraph 4.5 of his final report, Lord Justice Jackson noted the necessary elements of a QOCS regime were deterrence against bringing frivolous claims or applications, and then it goes on to explain that the proposed deterrence against such frivolous claims or applications was identified as the need to put the claimant at risk of adverse cost orders. And then later in paragraph 32, it stated that it's important that claimants are discouraged from bringing proceedings which are unlikely to succeed. Claimants with QOCS protection should not think that this general principle does not apply to them or that they can issue proceedings against any number of defendants without impunity. If the court then was right to consider the purpose and that the purposes of the QOCS regime are as I've outlined, the question then is, how does the judge's interpretation of proceedings further that dual purpose? And this is an issue which I sought to deal with in paragraphs 40 and 42 of my skeleton argument. Firstly, if the judge's construction is adopted, I say that a claimant whose claim for personal injury has been struck out under CPR 3.42a, whether or not such claim is brought in isolation or alongside other claims for non-personal injury damages, would not be entitled to QOCS protection. So the aim of discouraging those frivolous personal injury claims would be thereby achieved. At the same time, I would submit that the purpose of ensuring access to justice for claimants with meritorious personal injury claims, whether brought in isolation or in combination with other claims for non-personal injury damages, is furthered. Because in such cases, the presumption remains that QOCS protection applies, and in the latter type of case, could only be removed with the permission of and at the discretion of the court under 4416(2)(b). I don't understand the appellant to be suggesting that the judge's construction of 4415 should be rejected because it in itself would be inconsistent with the need to ensure access to justice. But of course, for completeness, I would in any event make the point that that argument would be ill-founded. The reason being that, in my submission, it cannot be said to be a deterrent and so an impediment to access for justice for a claimant seeking damages for personal injury to be placed at risk of an adverse costs order only if the court was to find that he had no reasonable ground for bringing that claim or otherwise fulfilled the requirements of 4415. Dealing specifically with the arguments that the appellants raised in the context of purpose, it has been said, at least in the skeleton, although not expanded on before your lordships this morning, that the purposive approach to construction adopted by the judge would have anomalous and unwarranted consequences for QOCS. So in the grounds of appeal, the appellant alleged that if the judge's decision was allowed to stand, it would have new anomalous and unwarranted consequences. The significant point being that he did not go on to explain, and neither has Mr. Lyon, what those alleged consequences would be. In my submission, that omission is telling, and it reflects the fact that in reality, it is not the case that the judge's interpretation of 4415 would have any such consequences. By contrast, it is the appellant's alternative proposed construction that would lead to undesirable results, which cannot, in my submission, have been intended. And initially, this follows from the approach taken by the appellant in the court below. Insofar as at that stage, according to the appellant's construction of 4415, as only the personal injury claims were struck out and not therefore all the claims and so the entire proceedings, QOCS couldn't be disapplied automatically under that rule. Instead, he went on. Instead, Mr. Lyon says now that in circumstances where damages for personal injury in a mixed claim have been struck out, the question of applicability of QOCS should be considered at the end of the case under 4416(2)(b). This was where I was proposing to deal with the point that your lordship has already asked me about, and in effect the difference between the parties as to the effect in the event that the appellant's construction was to be preferred. In my submission, if the court was to accept the appellant's construction of the rules and to find that in essence the appropriate course would be to await the outcome of the non-personal injury claims and then consider the question of costs under 4416, the practical consequence of this would be that a claimant would be able to benefit from a presumption of QOCS in every claim for non-personal injury damages by including a claim for damages for personal injury, however spurious. That would, in my submission, encourage a claimant to do exactly what Mr. Justice Foskett warned against in the Siddiqui case. In paragraph 8 of his judgment in Siddiqui, which is at page 91, he warned specifically of the need to guard against the risk of QOCS provisions being abused by dressing up non-personal injury claims in the clothes of personal injury claims to avoid the normal consequences of failure in litigation. Now, Mr. Lyon, in his submissions, focused on what I would submit would be extreme cases, at the extreme end of the spectrum, where essentially a personal injury claim is so fanciful that it could be considered to be fraudulent or an abusive process. Clearly, they aren't the run-of-the-mill types of unmeritorious claims faced by the court. The more likely scenario is that one doesn't have a personal injury claim so unmeritorious that it could obviously be described as fraudulent or amounting to abusive process. But it does still nevertheless cross the threshold for strikeout on the basis it had no reasonable grounds for succeeding. In those circumstances, neither of the options that Mr. Lyon pointed out would be available, and indeed wouldn't be commonly exercised by the court. And the more normal position in those circumstances would be, considering the question of costs under 4416, which has the problems and the disadvantages that I've already outlined. The other detrimental effect that the appellant's proposed construction would have is that it would lead to a situation where a claimant who brought a claim for non-personal injury damages alongside a claim for damages for personal injury would be entitled to greater QOCS protection than a claimant who brought a claim for personal injury damages alone in circumstances where the claim for personal injury was struck out. The latter type of claim would of course fall squarely within the exception to QOCS in 4415 as interpreted by the appellant, because the whole claim would have been struck out, but the former type of claim would not. And the illogical nature of that outcome was something that was acknowledged by the court in paragraph 50 of her judgment.
That was part of it.
Neither of those undesirable results, and certainly not the latter, has the appellant dealt with head on. Although there were obviously points made by the respondents of the first appeal and of course also accepted by the judge. The appellant has said that it's not open to the judge to adopt a purposive interpretation by importing a concept defined in the CPR into CPR 4415. That is the definition of a claim for personal injuries as set out in 2.31. I clearly have to accept that claim for personal injuries is defined in CPR 2.3 as meaning proceedings in which there is a claim for damages in respect of personal injuries to the claimant or any other person in respect of a person's death. And Mr. Lyon's already made the point, and I was going to make a similar one, that claims for personal injuries are referred to at various places throughout the CPR in a variety of contexts. I picked up on 16.3 relating to the nature of a statement of value included in the claim form without control F-ing, although now I know that that was an option, I perhaps should have done it. I'd also spotted 19...
It's quicker than getting the whole of the whiteboard.
I'd also spotted CPR 19.54 relating to the addition or substitution of a party after the end of the relevant limitation period. Suffice it to say, the circumstances in which that term arises are many and various.
Yeah.
The definition of the term in Rule 2.3 has no doubt therefore been drafted sufficiently broadly so as to work effectively in those different contexts. I don't accept that what the judge did in this case in interpreting proceedings in the way that she did, she thereby directly imported the term that was defined in the CPR. As to exactly how the judge did interpret CPR 4415, I'd invite the court to have regard to paragraphs 50 and 51 of the judgment, Her Honour Judge Kelly, at page 83. She deals with it in two places. So, at the top of paragraph 50, in my judgment, the construction of the word proceedings in CPR 4415(1 as meaning the personal injury claim alone, rather than requiring the strikeout of all claims, both personal injury and non-personal injury, is consistent with the context and purpose of the QOCS regime. And later, at the end of paragraph 51, in my judgment, the narrower meaning of proceedings in CPR 4415(1 to mean the personal injury claim alone achieves what is clearly the common sense outcome that furthers the purpose of the QOCS regime. Both passages make clear that what the judge sought to do was to distinguish between a claim for personal injuries from any other sort of claim in a mixed claim. And the references to a personal injury claim alone in that context. She wasn't directly importing the definition of a claim for personal injuries from CPR 2.3. I would submit that the definition of a claim for personal injuries in Rule 2.3 was designed to apply in entirely different circumstances to those very specific circumstances now under the consideration of this court and previously under the consideration of the judge at first instance. And the mere existence of that provision ought not to preclude the judge from adopting a purposive construction to the specific provision before her. Moving on to deal with this point about, in reliance, on the Inco Europe case, it's said essentially that what the judge did should be interpreted as amounting to a finding that a drafting mistake had been made, and therefore that she went beyond the standard interpretive function of the court because consideration was not given in particular to the criteria in Inco Europe. The respondent doesn't accept that in adopting the purposive construction of the term proceedings in CPR 4415, the judge did go beyond the standard interpretive function of the court. I'd submit that the situation faced by the court, just using the Inco Europe as an example, is very different to the situation faced by the judge in this case. In Inco Europe, the issue was whether an appeal could lie to the Court of Appeal from a decision at first instance made under Section 9 of the Arbitration Act 1996, whereby the court had refused to grant a stay of legal proceedings. It depended on the interpretation of Section 18(1) of the Supreme Court Act 1981, as had been amended by the Arbitration Act in Sections 107 and Schedule 3. The House of Lords held that the Court of Appeal did have jurisdiction to consider an appeal, but in doing so, it was required to read words in to the relevant statutory section. And you've been taken to part of the Inco Europe case insofar as it set out the test, but if I may wish to refer you to a different part of the judgment of Lord Nichols, which is on page 87 of the authorities bundle.
Mm-hmm.
So as to make clear the extent of the reading in that was required in that case. The relevant paragraph, it's 592B and C, beginning thus the new section. It says, thus the new section of 18(1)G, substituted by paragraph 37(2), should be read as confined to decisions of the High Court under sections of Part 1 which make provision regarding an appeal from such decisions. And then it's the next part of the paragraph that sets out the extent of the reading in that the House of Lords had to do. Lord Nichols went on to state, I freely acknowledge that this interpretation of section 18.1g involves reading words into the paragraph. Long been established that the role of the courts in construing legislation is not confined to resolving ambiguities in statutory language. It was in relation to the former type of case, where there's an obvious drafting error warranting reading in, I would submit, and not the latter type of case, where the court is merely resolving ambiguities in statutory language, that the court ought to consider the three matters referred to later in the judgment at 592 F to G. What I submit the judge in this case had to do was to resolve ambiguity as to the meaning of the word proceedings by determining whether it meant all claims brought by the appellant against the respondent or only the personal injury claim. So I say the judge was exercising the alternative type of interpretive function that Lord Nichols alluded to in INCO Europe. So the respondent's primary position is that it's not necessary for the court to have expressly considered the three matters which Lord Nichols referred to. I'd also make the separate point that the judge in this case did no more than the High Court had to do in the case of Jeffreys. This isn't a case which is included in the authorities bundle, but it was a case that the judge cited in her judgment. And if I could refer you momentarily to paragraph 34 of the judgment at page 76 and 77. This was a case concerning the interpretation of CPR 16(2)b, and it was the case in which the drafting problem within that section was identified insofar as it refers to a claim to which this section applies when 4413 didn't use the same terminology. What Mr. Justice Morris said in paragraph 37 of the case, in Jeffreys, and this is cited in paragraph 34 of the judge's judgment, was that in order to give meaning to the phrase, a claim is made other than a claim to which this section applies, in CPR 4416(2)b, it must be interpreted as referring to proceedings which include a claim other than a claim for damages for personal injury. And he did so without the need to consider the INCO Europe criteria. The second reason why the respondent says that the judge's decision and reasoning was correct was that it was consistent with case law insofar as there are reported decisions on the meaning of the word proceedings in section 2 of part 44. Both from a general and a specific perspective. In particular, the judge's construction of 4415, which relied on a narrow interpretation of the word proceedings, in my submission, is in accordance with the Supreme Court's approach to the meaning of that word, albeit in a different context in Plevin. You've already been taken to paragraph 20 of Lord Sumption's judgment by Mr. Lyon. But the point I want to emphasise is that whilst Lord Sumption stated that the starting point was that as a matter of ordinary language, one would equate proceedings with an action, it was made clear that in appropriate circumstances, depending on the statutory context and the underlying purpose of the provision in which the term appears, that the ordinary meaning could be displaced. And for example, Lord Sumption highlighted that that was the exact position that pertained in the costs cases he'd referred to previously in paragraph 18. Respondent submits, for the reasons that I've already referred to relating to the purpose of the QOCS regime, that the ordinary meaning of the term should likewise be displaced when interpreting 4415. But I would make the point that the judge's interpretation of 4415 was not only in accordance with Plevin and the general approach in case law to the meaning of the word proceedings, but it was also consistent with other case law, specifically in a QOCS context. For example, the Wagner case, which, as your Lordship will be aware, when considering 4413 as excluding a claim for contribution or indemnity brought by a defendant to a personal injury claim against a third party. In the context of Rule 4413, they interpreted proceedings as excluding that type of claim. As a result, QOCS only applied to the personal injury claim brought by the claimant against the defendant in that case, and not all of the claims in the action. That, in my submission, is an example of the Court of Appeal doing exactly what the judge did in the circumstances of this case, insofar as it, in my submission, adopted a purposive interpretation which led to a narrow interpretation of the relevant term. The other case that, of course, I say supports the decision is Day and Bryant, but if I may address that in a moment. First of all, I just wanted to deal with the case of Howe and the MIB, which is referenced and relied upon by the appellant. The appellant has noted that in reliance upon Plevin, the Court of Appeal in Howe held that proceedings in CPR 4415 could be interpreted broadly enough to include an appeal arising out of a claim to which QOCS applied. And the appellant has also flagged up that the Court of Appeal in Cartwright had noted that Howe had adopted a wide meaning of the word proceedings in relation to 4415. Insofar as it is said as a consequence that it's therefore appropriate for the judge to have adopted a similarly wide interpretation of proceedings in this case, the respondent's position is that does not and should not follow from the decision of the Court of Appeal in Howe. There's a number of contextual points to be aware of in relation to Howe. It was an extempore judgment given at the end of the appeal. It did concern the scope of CPR 4415, but it did so specifically in the context of the strikeout of an appeal. It wasn't dealing with a situation before the court in this appeal concerning the strikeout of part of, but not the whole of the claim. And the application of the QOCS exception in Howe was rejected on the basis that the appeal had not been struck out because the claimant had no reasonable grounds for bringing it. In fact, the appeal had been struck out after the appeal was brought because that was the point at which the law changed. So a key precondition to the application of the QOCS exception in 4415 had not in any event been satisfied.
Was Howe overruled in Hoe and Adelecan?
Not dealing with this specific
Not on
point.
this point.
Hoe and Adekalian?
Whatever.
Top of my head, can't remember how it's pronounced. Obviously dealt with the question of set-off. And the Court of Appeal felt bound by
The Court of Appeal
Howe.
said that they were bound by Howe, but thought it was probably wrong,
Yes.
and gave permission to appeal. The Supreme Court said permission should not have been given, but allowed the appeal.
Yes, in relation to the set-off point, but not in relation to this aspect of how that deals with
But
the
that wasn't-
interpretation
you're right,
of
that wasn't
4415. Much was made, certainly in the skeleton, and indeed in the original petition to appeal skeleton, about the suggestion that the judge's interpretation was contrary to the approach taken to the meaning of proceedings in the Brown case. Less emphasis has been placed on that during submissions this morning, but I feel that it's important for me to set out the respondent's position insofar as the respondent says that that is not in fact correct. In Brown, of course, the Court of Appeal held that in mixed claims, costs orders could be enforced with the permission at the discretion of the court under 4416(2)(b). The appellant effectively relies on Brown to argue that questions of enforceability of costs orders in mixed claims are discretionary, should be made following trial, even in circumstances where the claim for damages for personal injury originally forming part of the mixed claim is struck out. And that is the ultimate outcome of the appellant's argument based on Brown. It is apparent from paragraph 43A of the skeleton, indeed is a point that's been made this morning. In this way, in the respondent's submission, what the appellant is seeking to do is to extend the ambit of the Court of Appeal decision in Brown beyond the strict confines of CPR 4416(2)b, which was of course the provision with which that case was directly concerned. Your Lordships, having been taken to paragraph 36 of the judgment, will know that it's not the case that the judge did not refer to Brown at all. She expressly referred to it in her judgment, and it having been an authority that was specifically relied upon by the appellant in the first appeal, as well as, of course, having been drawn to the court's attention by myself. Initially, the appellant argued in the petition to appeal skeleton that the judge was wrong because she ignored the decision in Brown entirely, which is clearly unsustainable. The position now is more nuanced. What it is alleged now is that the judge's decision in this case was contrary to Brown because it is said that Brown established a distinction between proceedings and a claim, which distinction was overlooked by the judge. And it's implicit in that position not only that such a distinction was drawn, but that it ought to apply not only to the circumstances as they pertained in Brown, but also to the circumstances of the appellant's case. Now, I've already, I hope, made clear that in the paragraphs of Lord Justice Coulson's judgment to which your Lordship's already been taken.
Do you want to take us back there? Sometimes
yes, it's paragraphs 31 to 36.
Yep, yes.
And I think you've accepted, haven't you, that there is a distinction in other parts of the QOCS rules, but you say because 4415 has a different purpose, that distinction does not carry through into 4415.
Yes. I accept that in those paragraphs 31 to 16, a distinction is drawn in the context of 4416(2)b between proceedings and claims being two different things. Where the difference between the parties lies is, as your Lordship has identified, as to whether that distinction should nevertheless apply to the circumstances of the appellant's case. But if I may, going back specifically to the relevant part in Brown, which is page 13. The comments made by Lord Justice Coulson in his judgment in Brown, which are relied on now by the appellant, were made specifically when he was considering the interpretation of 4416(2)b. And I'll note that the heading of section 5, the exception at CPR 4416(2)b, and the proper interpretation, it is manifestly evident that those comments were made in that
Yes,
context.
but what he says is, in paragraph 33, is the exception in 4416(2)b was designed to deal with the situation where a claim for damages for PI was only one of the claims made in the proceedings.
In the
So that is, this case falls into that category, doesn't it?
Well, save that. That comment has to be read in the factual context of the situation in Brown.
Why?
Why
does it have to be? Why isn't it just a general? Why is it applicable generally? That's what where you've got a claim which is where you've got proceedings which include a claim for PI and a claim for something else. They fall within 16(2)b. Isn't that what he's saying? Full stop.
In my submission, no. I'd say one has to read those comments in light of the factual circumstances in Brown, whereby there had been no strikeout of the personal injury claim. What the court was looking to do was deal with a mixed claim following the trial of the matter. At which point, it was only at that stage, following the trial, that the claim for damage for personal injury had
But
been
the way
rejected.
16(2)b is drafted doesn't confine it to those circumstances, does it? At first blush, 16(2)b would seem to include the current situation, doesn't it? The claim is made for the benefit of the claimant other than a claim to which the section applies. The section applies to PI claims. So the proceedings include, if the proceedings include both types of claim or another type of claim in addition to PI, a PI claim, It falls under 16(2)(b).
At the outset, yes, Your Lordship, but of course there's the problem that at the point at which the costs is being considered, the personal injury element of the claim has in fact been struck out.
Right.
And so at the point that the court is considering the question of costs enforcement, on one view, the claim is no longer a mixed claim because it is simply, on the facts of this case, a claim for injury to feelings for breach of statutory duty, and so no longer a claim.
That doesn't matter, does it? The way it's drafted is a claim is made for the benefit of the claim other than a claim to which the section applies. That wording doesn't create that problem.
Well, certainly the respondent's position is that Brown is not authority for the court to apply 4416(2)(b in circumstances which weren't before the court in that case, which are before the court in this case, according to which the personal injury claim.
And 4416 gives the court a discretion, which 4415 doesn't. Isn't that likely to be more consistent with justice in a situation where we've got two claims, one of which has been struck out and the other which hasn't?
No, Your Lordship, I'd say in fact the exact opposite, for the reasons that I've already dealt with. The possibility of the defendant obtaining a costs order to an uncertain extent is by no means as advantageous to a defendant as an automatic entitlement to enforcement of costs. And the problem with that is that it does not serve one of the primary purposes of the QOCS regime to deter unmeritorious personal injury claims.
Even on Mr. Lyon's case, 4415 does apply to mixed claims. It's just that it only applies, he says, if all of the claims are struck out. So one could say, I suppose, that 4415 is also designed to deal with the situation to which Lord Justice Coulson refers. It's just a question of how far does it apply.
And I think it's in drawing that boundary that I'd fall back on the purpose.
Yes.
Are you going to say anything about whether or not 4414(2) should be read as having the word subject to rules 4415 and 4416 read in or not?
Yes, I was.
Sorry, if you're coming on to that,
I was going
to the time, I mustn't lead you.
I was going to deal with it in the context
Come on to
of
it.
the argument about inconsistency with the CPR more generally.
Okay. Well, when you get to it when you want to.
The next point I was going to make was the argument the respondent that the appellant has raised to the effect that the interpretation of proceedings contended for by the respondent, reliant as it is on a single head of claim and consequential damages brought by a single claimant against the defendant, is novel and unprecedented. What the appellant says is that there's no case law which suggests that proceedings has ever been defined as limited to a single cause of action or a single head of damages brought by a single claimant against a defendant. The first point that I'd make on the respondent's behalf is that respondent does not contend for, and the judge did not accept, a definition of proceedings in 4415 which was limited to a single cause of action. Clearly, a personal injury claim or a claim for damages for personal injuries is not a cause of action at all, but is in fact a claim for a particular head of loss. I accept that the judge did define the meaning of proceedings in 4415 by reference to a single head of loss, but insofar as it said that that approach is novel and unprecedented, to a certain extent that's stating the obvious, in that the unprecedented nature of this case explains our presence before you this morning. The more pertinent point to make is that whilst there is no previous authority directly on point, the High Court case of Day and Bryant is, in my submission, of significant weight insofar as it specifically dealt with the interpretation of proceedings in CPR 4415 in directly analogous circumstances. In Day, the court considered whether, for the purposes of the application of the exception to QOCS under 4415(1)b, it was enough that the claimant's claim for personal injury had been struck out as an abusive process in circumstances where the defendant's counterclaim for declaratory relief arising out of exactly the same circumstances proceeded to trial. The court held that it was, and that the exception to QOCS under 4415 applied. Your Lordships will no doubt be familiar with the somewhat unusual circumstances of that case. But essentially it concerned a claim being issued by a claimant for damages against Dorset County Councillor Mr Bryant for assault, battery and false imprisonment. And as a result, the claimant alleged he sustained psychiatric injury, which he claimed deprived him of a successful boxing career. By way of a counterclaim, the second defendant sought factual declarations fundamentally denying the factual basis of the claimant's case. The claimant failed to participate in the litigation and comply with court directions, and it led to Mrs Justice Whipple to order the claimant to notify the court and the defendant in writing of his intention to pursue his claim, in default of which the claim should stand struck out for want of prosecution. Suffice it to say, the claimant failed to give any such indication and the claim was automatically struck out. And it was the subsequent trial of the counterclaim seeking declaratory relief that came before Master Thornett and was successful. And it was at that point the question arose as to whether the claimant was protected by QOCS or whether the exception to 4415 applied. And the key paragraph of Master Thornett's judgment in Day, which the respondent submits is directly relevant to the circumstances of the present case, is paragraph 19 at page 102. In that paragraph, he stated that for the purposes of CPR 4415(1)b, therefore, the claimant's case has been struck out for abusive process. I do not think there is any relevant distinction to be made here between the striking out of a claim and the striking out of entire proceedings, because it's only the personal injury claim that attacks the QOCS provisions. Counterclaims are rare. Therefore, if the claim is struck out owing to abuse, it in turn sees a striking out of the entire proceedings. But in the more unusual case of a claim that additionally includes a counterclaim, it's appropriate to interpret the QOCS exception as applying to the striking out of the claim of the party that has benefited from QOCS. It didn't therefore matter, insofar as the exception to the QOCS under 4415 was concerned, that the counterclaim for declaratory relief had in fact proceeded to trial. It's the respondent's position that the decision in Day is correct. The judge was right to rely on it. And in essence, insofar as the judge in that case emphasised that there should be no relevant distinction made between the striking out of the claim and the striking out of the entire proceedings, it clearly supports the interpretation that the respondent is seeking to advocate this morning.
It's not a mixed claim case. It struck out the entirety of the claimant's claims. Is that right?
Yes, save that the counterclaim was based on the entirely the same factual matrix.
Yeah.
Well, no doubt that decision is right, but it could have been reasoned in a different way, couldn't it? The proceedings and all of them which the claimant had issued had been struck out, leaving behind some proceedings that the claimant had not issued. Somebody else had issued them against him.
Yes, although...
which were obviously separate.
Yes, although it would appear, at least from paragraph 19, that was not the reasoning.
No, it wasn't.
Now it's 25 to 1. We have to finish at 1. Mr. Lyon has to take some instructions before his reply. So I think I'm going to say 10 minutes maximum, please.
In which case, Your Lordship, I'll move straight on to this issue about interpretation. The appellant says that the QOCS provisions within the entirety of Section 2 of Part 44 are designed to be read together such that the term proceedings must be interpreted in the same way wherever within that section appears. And the respondent has the appellant has pointed to the fact that other QOCS provisions like CPR 4413 proceedings has been interpreted differently to the way in which the judge interpreted the term in 4415. So the argument goes that the judge's interpretation is wrong. As I perhaps already touched on, the respondent doesn't accept the premise of that argument that the term proceedings must be interpreted in the same way wherever within section 2 of part 44 that the term appears. I'd fall back on Plevin, as I said earlier, that the meaning of a term must depend on its specific statutory context and the underlying purpose of the provision. And the mere fact that both 4413 and 15 appear in section 2 doesn't mean the purpose of the two provisions are the same. And I've already, I hope, addressed why I say, in fact, their purpose is different and why that would warrant a different approach. Your Lordship asked me specifically about how I deal with 4414.2. That provision provides that orders for costs made against a claimant may only be enforced after the proceedings have been concluded and costs have been assessed or agreed. The judge dealt head-on with the argument which has been made by the appellant in similar terms on the first appeal, and did so in paragraph 46 of her judgment. So pages 81 to 82, which begins, the appellant adopts the point raised but not decided by Her Honour Judge Truman that CPR 4414.2 supports his construction. The judge dismissed the appellant's argument that 4414.2 precluded her from adopting the interpretation of proceedings that she did for two reasons, and the respondent's position is that she was right to do so. I'd make the point that 4414, subparagraphs 1, 2 and 3 all appear under the heading effect of qualified one-way costs shifting. They're all dealt with under the same particular rule. Rule 4414 in effect sets out the general rule in relation to QOCS, and as can be seen from 4414.1, the general rule is specifically stated to be subject to rules 44.15 and 16, and so the exceptions. And I say that the meaning of 44.14.2 has to be approached in that context. The fact that 44.14.2 appears immediately after the general rule in 44.14.1 and under the same overall heading indicates that 44.14.2 relates only to a case where the general rule under 44.14.1 applies, and as such is also subject, in my submission, to the exceptions under 44.15 and 16. And that was the point that the judge in paragraph 46 goes on to make, where she says, however, the effects of QOCS under CPR 44.14 is said to be subject to rules 44.15 and 16.
Well, yes, 44.14.1. It should actually say, shouldn't it? In that sentence, beginning, however.
I think, Your Lordship, that it was deliberate because she was accepting the point that I've made a moment ago,
Okay.
that it's all part and parcel of the same rule 44.14. So I think the omission of the reference to 1 is deliberate.
Well, oh, I see. Well, I don't actually see. Because 40... Is she saying that the rule includes the word subject to? Then it's 40. It's only there in 44.1.
It's only specified at the beginning of Rule 1, but I think the point that the judge was making here...
You were saying that it was, and she was accepting it.
Yes. The other point that the judge...
Sorry. You go on.
I would say, does the proceedings in 44.14.2 mean the same as in 44.13 or the same as in, you say, 44.50?
Well, you anticipated the next point that I was going to make, and the point that I think the judge goes on also to make was that what it would be open to interpret the word proceedings in 44.14.2 in a manner consistent with 44.15.
That's what she says. She says applying a purpose of construction.
Yes.
The phrase there is proceedings have been concluded.
Well, insofar as
where one claim is struck out, or what is struck out, the proceedings haven't been concluded, have they? So you have to interpret concluded in a particular way as well, don't you?
well, I'd say that if one interprets the proceedings as the personal injury claim alone, then potentially they have been concluded in circumstances where there has been a strikeout. So it wouldn't pose a problem for a respondent in the same position as the Lawn Tennis Association from enforcing a costs order at an interim stage. I'm conscious at the time there was only one final point that I wanted to make.
So just so I'm clear, what do you say? Are you saying that it's not subject? You're saying that it is subject to Rules 44. The whole thing is subject to. So we should read 44.14 as if the word subject to Rules 44, 15 and 16 appeared before 1, 2 and 3.
Or alternatively, proceedings within 44.14.2 bears the same narrow construction as it does in 44.15. The final point I wanted to make is that this appeal is not about whether the word proceedings in my submission in 44.15 should be given a broad or a narrow interpretation in general. It's about whether the word should be interpreted narrowly in this specific context, i.e. in the context where the claim for damages for personal injury to which QOCS protection attaches in a mixed claim has been struck out. It's perfectly possible that in the same way that other QOCS provisions, like CPR 44.13, are interpreted broadly in some contexts, i.e. to include appeals and claims against multiple defendants, and narrowly in others to exclude third-party claims, that 44.15 can also be interpreted narrowly in this case, but more broadly to include an appeal, as was the case in Howe, where it would be consistent with the underlying purpose of the QOCS regime to do so. So unless your lordship had any further...
Just so that we're clear then, we'll just going through 44, and in some places proceedings means proceedings, and other places it means claim, PI claim. Yes? So you say it mean, in 44.13 it means proceedings.
Yes, because a specific distinction is drawn between proceedings and a claim.
In 44.14.2 it means claim for PI.
Yes, although in any event I say it is required to be read subject to the exception.
And everywhere in 44.15, it's used several times in 44.15, at all points it means claim for PI, does it?
Dealing specifically with...
So in 44.15, 1, 15, 1B, 1A, 1B, and the last word, 1C.
Yes.
In each case, it means claim. And then in 44.16, it means, if it's 16.2a, it means proceedings. Yep.
Yes.
Okay. Thank you.
And then obviously B, as interpreted in...
As you mentioned. Yeah. Right. Now we'll rise. Are you in easy communication with your client?
Yes, my learned junior has kindly given his mobile number, so that is how communication.
Well, I suggest we rise for 5 minutes. I think that ought to be sufficient to get instructions.
The only issue is what the delay on the streaming is. I don't know, because obviously that's his only access to the...
Yes, it's I think it's a 90-second delay. I think
It's not very long.
Oh.
I don't remember exactly how
Anyway,
long. It's not very long.
Okay. So I don't think that should cause a problem. But we'll be outside, so let us know when you're ready. But I'm expecting it to be 5 minutes.
I'm great.
Thank you.
Will you let me know then when you're ready?
Yes, we'll be right back.
All rise.
Yes, Mr. Lyon.
I'm grateful for the time, my lords. I have been able to take instructions. I think the first and really crucial point to respond to is this point about purpose and the purpose of the QOCS regime. Now, I accept completely what my learned friend says, that there are the two purposes that need to be balanced and also complement one another. Firstly, allowing access to justice for those claimants with personal injury claims.
Yes.
And secondly, deterring frivolous personal injury or unmeritorious personal injury claims.
They're not the same thing, frivolous and unmeritorious. They're different, aren't they?
Yes, I would say so. I think that's probably correct, my lord. The issue with this is the way that it's been addressed is largely looking at the disadvantages to the defendant. What I have made clear, I hope, in my submissions earlier, is that it's in fact leaving the claimant with a great deal of risk bringing those sort of claims. And from a human behaviour perspective, you might certainly think that a claimant looking at this, even a very sophisticated litigant, wouldn't go, oh, well, I might be able to get away with being able to persuade the court that I've still got QOCS protection the whole way through. They're going to see the risks. And the risks are huge for claimants in that position. Because of the fact that they've got potentially the fundamentally dishonest finding, potentially the strikeout of their entire claim as an abuse process, but also the exercise of the judicial discretion under 4416. It's totally, it's not inconsistent in any way with the purpose of the QOCS regime that this particular provision of 4415 wouldn't bite in this very specific circumstance. So I don't say that it is inconsistent with that purpose of the QOCS regime to have the interpretation that I suggest for those reasons. I think that's something that is emphasised in Cartwright, paragraph 31, which you've already been taken to by my learned friend. That is the need to put the claimant at risk of adverse cost orders. Well, as I say, the claimant is put at risk of adverse cost orders by these other provisions, just not necessarily by this provision in these circumstances. It was also said that I hadn't addressed the consequences of the term. I think I had, particularly with reference to 4414.2. And I don't know if you have my point on that already, my lords, or whether I need to reiterate that. But
why don't you tell us in a sentence what you would say?
Yes. So my learned friend suggests two interpretations of 4414.2. Firstly, that it is subject to 4415 and 4416.
Yeah.
That has, I say, grave consequences for the first objective of QOCS, to promote access to justice for claimants with personal injury claims, because it would allow an interim cost order to be enforced under 4416 and leave a surviving personal injury claim with a claimant with an adverse cost order against them, causing them to have to go out of pocket and causing potentially access to justice problems, which the entire system was designed to prevent. So that can't be right. But the second interpretation, which is that there is a different interpretation of proceedings between 4414.2, 4415, those are interpreted the same way, 4413 and 4416 interpreted differently. I say it doesn't hold water partly because 4414.1 makes reference to both 4415 and 4416. They're clearly referential paragraphs, and at that point it really doesn't stand statutory construction to have them different or interpreted differently. In terms of the ambiguities of the statutory language, the argument that there's no need to read in words, I say that it does go beyond the normal interpretive function of the court, because what is being suggested is an entirely new and a novel definition of proceedings. And it's that definition that I describe of subdividing and bifurcating a single claim into multiple proceedings, or a single claim form, I should say. Proceedings brought under a single claim form into multiple proceedings. It hasn't been specified how this defined term differs from the imported term. And I say the reason it hasn't been specified is because it doesn't. It's the same. Lastly, the interpretation point. There must, I say, be a strong presumption, and this is going back to the point that I raised in Pleven, paragraph 22. There must be a strong presumption that all of these provisions are read together, and it must be that they are read and interpreted in the same way. And that's very clear from Lord Sumption's judgment in that case. But I'm sure, my lords, you have the point.
Yes.
I don't think I need to add anything further.
Thank you.
Oh, sorry, yes, there was just one thing.
Yes.
Do you accept that on your interpretation, what the judge said is correct? That is to say that a claimant pursuing a personal injury claim tacked on to a non-personal injury claim is in a better position than a litigant pursuing the same personal injury claim alone.
Depends how you define better, I think, my lord. What I say is they're in a fractionally better position and they don't have an immediately enforceable cost order made against them. They're also in a better position because they don't have, it's not an automatic cost order, enforceable cost order made against them.
So better, but not so much better that it should cast doubt on your
To
interpretation.
cause everything to be reread in order for that interpretation to make sense.
Yes. Thank you.
Thank you. We're very grateful to both of you. We've been struck by the quality of these submissions, both in writing and orally. So, well done. Thank you very much. We're going to reserve our judgment in this case. That means at some time in the future you will receive a draft judgment, which will be an opportunity for you to point out any minor factual errors or typographical errors. Not obviously a chance to re-argue any of the points. When we've had your comments about that back, the judgment will be handed down in due course under the new rule, which will not require any party to attend. I remind you of the very important rule that draft judgments sent out are confidential and must not be disclosed to anybody other than those to whom they are sent, without the court's permission. When we do send out our draft judgment, I'd be grateful if you would agree the terms of the order with any consequential orders included. If there are any issues which are outstanding, then we'll consider them on the basis of written submissions. Thank you very much.
Well, guys.